Welcome to Direct Examination presented by UBS. Along with Lauren Youngman from Youngman Reichstein, I'm Dan Bemel, financial advisor and certified divorce financial analyst at UBS Private Wealth Management. Up to this point, we've featured Los Angeles area attorneys, judges, and mediators across 35 episodes. Now, we're going to start mixing in the most talented and well-regarded family law practitioners across the country. So to begin that journey, we turn today to preeminent San Francisco attorney Jill Hersh.
Jill is the founder of Hersh Family Law Practice, where she leads a dedicated and diverse team. Since joining the bar, Jill has seen and contributed to significant social and legal changes, including no-fault divorce, expanded rights for women and same-sex couples, and the complexity of modern family structures. Now her practice includes a large international component, broadening her reach and impact even more. We're excited to explore all of that and more. Jill, thank you so much for being here.
Thank you for having me.
All right. Well, as Lauren said, we do really appreciate you joining us. Lots of pressing family law issues we want to discuss. So let's dive right in and start with some questions on interior design. I think that's the best place to start, obviously, right?
Yes.
Yes, of course. So the physical space that you built, I think, is really unique for not just family law, but for any attorney's office. It's created for people who haven't seen it or visited. It really feels like a living room space for clients at the heart of the office, and then a ring of offices around and behind that. So how does that physical space that you built, how did you come to want to build a space like that? And how has that changed the dynamics of the practice?
Well, so my earlier office had been built by the men who I joined as a partner years before. So this was the first I shed them, and gradually. And this was the first space that I really could create. I guess you could say in my image. I said to you, Dan, before we met, if you see my office, you know a lot about me. So, there are two things that nobody ever wants to say, my oncologist and my divorce lawyer, and not necessarily in that order. So the space was designed to try to alleviate as much as possible the stress and anxiety and angst that people necessarily bring in when they come to see a divorce lawyer, because let's face it, it's not in anybody's fantasy future plan to be getting a divorce.
And do you feel that as your practice has evolved in that space, have you felt a shift from the clients?
Clients really appreciate it. When they get off the elevator, if you look at the website, you can see it. When you get off the elevator and the doors open, you're just presented with a living room that has two different seating areas, so that if there's more than one client waiting to see somebody, they don't have to be sitting together in the same space. They can have a modicum of privacy, but it's all art books and Vanity Fair, and I think the New Yorker's out there, and some other miscellaneous books. There's a book on the study of the relative well-being of children raised in modern families. But generally speaking, it's distraction. It's distraction material. And there are couches and comfortable seats and comfortable lighting and little art things around. And then the shelving that creates that space, the walls of that space, are all old, mostly old, but all legal reported cases. So it's very pretty. They're very pretty. The books have a muted color to their binding.
Does the physical space change how attorneys and staff use it or collaborate?
Yes.
How
so? For example, there's an organization I'm on one of their boards, and they need a place to meet. We come and meet there. For our annual sort of Thanksgiving lunch that we all eat in there. We have meetings in there. People just sit around and visit in there. Dan and I sat around in there to visit. We're having on Thursday evening a memorial reception for Justice King, who died on November 15th. And the living room is a fantastic space for that. And anteroom where you get off the elevators where the bar and the little jazz trio is going to be. So it just opens up, I think people are so busy using up all the space they've got that they're not necessarily thinking about the rhetoric of the space and how they're presenting themselves. And I just really wanted people to get off the elevator, if it was at all possible, feel that there was some reduction of anxiety and stress when they saw the environment they're coming into.
So that's a super thoughtful physical approach to that intersection between psychology and family law, and how you want both your team and your clients to feel and think when they're in that space. Where else have you tried to build that into your approach to the practice, whether that's firm culture or just that intersection generally?
Well, I think family law is both a helping profession and a service profession. And I think I told you the story about a man who came. The mood of his arrival was like he ran into my office from someplace else where the previous lawyer had said, "Who do you think I am? You're a psychiatrist?" Although his language was a little bit more colorful than that. And so I don't think that we can really support our clients through the process if we're not aware of the psychological issues that are out and about. And often clients present way more composed than they feel internally. One of the things I always say to people who I've met with is never feel uncomfortable or sheepish about asking a question more than once. I don't expect you to remember everything we talked about. When people feel they could be sitting very poised, but internally there's a lot of turmoil and there's a lot of anxiety. It's very hard to lay down information and retain it under those circumstances. So the people who work here, the lawyers who work here, are required to work with a mental health consultant, the same way that psychologists work with a mental health consultant. They have somebody, first of all, they have to have 3 confidential visits with our consultant once they're hired. That's part of the sort of onboarding process so that they get to know each other. And then they have that resource available to them both to figure out what's getting set off in them by what the client is bringing in, which we call in psychology countertransference, and what is getting set off in the client. And so that they're able to hold the client's process or anxiety or distress or interpret better because their own interior issues are not getting involved in the communication. I think that's really, really important. I remember walking by someone's office years ago and hearing him say to somebody, "Just calm down." Well, it has the opposite effect. And when you say just calm down, it's because the other person is giving expression to some amount of anxiety or worry. And instead of being able to hold that and interpret that for them, the person who listened, it set something off in him and he wanted to go away. That's countertransference. So as a result, what he did was counterproductive. What he said to the client was not empathic, I guess would be the way to say. You've got to learn to have empathy and good boundaries at the same time. And you also have to learn to be able to interpret what you're hearing. And some of that is just experience, and some of it is psychological acumen, and some of it is the help of a consultant.
As financial advisors who specialize in divorce, our team's first priority is to help family law attorneys get the best possible outcome.
And we strive to help clients be better partners in their own case through education and support. The forensic accountants build the balance sheet, but we are your translators, teaching the basics to clients who may have limited financial experience. And then we look behind the numbers to find benefits and avoid traps so you can negotiate a better deal.
Real-time financial analysis gives clients an anchor in what can be a fast-moving and confusing experience, connects the balance sheet and legal strategy to real life, and answers the fundamental question, will this settlement be enough? We run Monte Carlo simulations as negotiations develop, controlling for even the most granular aspects of a proposal. This changes the dynamic in the room and empowers clients to focus on their next chapter instead of just on the fight.
Engaging with financial issues early in a case is the key to long-term success. And as the case winds down and you pass the baton, we monitor the deal to ensure all your hard work has a lasting, positive impact in each client's life.
Working together adds firepower to your team and brings a depth of knowledge and advice in service of better outcomes and more satisfied clients.
How relevant is the attorney's state of mind and empathy generally to working in family law cases?
I think it's material. But I think self-awareness, I mean, you know, what I hope is that people who go into family law have done their own personal work, but you can't make people do that. Right? And so the closest I can get is having our lawyers have a consultant to talk to, not for therapy, but for feedback and to help them assist and support them, because it is until you develop really good boundaries, you can be a passive receptacle, and that is for people's worries and fears and anxiety, and not know what to do with all of that, right? And so learning the boundary, but also being able to give expression to empathy. I was talking to somebody the other day, and he was describing a situation to me, and I said, "You're describing somebody who's mentally ill." And he said, "Yes, I am. That's right." But I had to listen to what he was telling me so that I could understand it. And then you have people who have been in abusive relationships for years, and abuse takes all different forms. And learning how to talk to those people is a particular challenge. There are some people who aren't ready to know that they're in an abusive relationship. And we also have to be very careful not to reenact the dynamics of an abusive relationship, which can inadvertently happen. We also have to be able to identify people who are actually unable to receive help.
When it comes to the practice,
sorry, Dan, what?
No, please.
The lawyer has to be able to tolerate that some people are not able to receive help.
So I'm curious if we could dig in more there. I mean, the idea of the mental health amongst your team. What else? The intake piece is super interesting, but once you're past that, and you've had lawyers with you for decades now, how do you continue to promote good mental health and self-care behaviors? And really, what are they? What do you want your lawyers to be doing?
Well, I want them to have balanced lives. You know, so one of the lawyers in my office built her own house, literally built her own house.
Like hammering, actually
Yes,
hitting the nails.
yes.
Yeah.
She's a very petite woman, and there's a picture of her with a tool belt up on the roof of her A-frame house in Tahoe, right? She
Awesome.
literally built her own house. You know, another lawyer keeps a guitar in his office, and he takes guitar lessons and he plays guitar, and you know, everybody has, well, I hope everybody has other interests. And also, we don't have a structured vacation schedule in our office where, you know, if you've been here such an amount of time, you get a week off or whatever it is. And so people have a lot of autonomy. And I think a feeling of autonomy also contributes to a feeling of mental health. When you feel like you're being controlled all the time or judged all the time, I think that's stressful. So it takes some getting used to for some of the lawyers that come here from other firms. I had one lawyer come in here and she had nothing on her walls. I said, "Are you planning on putting anything in on the shelves or on the walls? What am I allowed to put up?" And I said, anything you want to. She said, oh, really? I said, yes. She said, well, the place I came from, it all had to be a certain color. And I said, oh, I said, well, just do whatever you want. Or, I have a sitting room where I see clients that's like a little living room. And I had somebody come in once to sit down and talk to me. She was the same person. I had her come in and sit down. She said, where should I sit? I said, anywhere you want to.
That's what you said to me. It was very confusing.
Right. So it's
like, yeah, but where? But where?
But where? So it's what goes on outside the office, but it's also what goes on inside the office. And it's very collegial here. And there are, honestly, this is going to sound really weird, but I just looked in my email and they're planning a board game night. And there was a karaoke night, and there was a night everybody went bowling. And this afternoon, the staff is all going out to lunch together. And so it's a combination of the culture inside the office, and then hoping that everybody is pursuing their interests outside the office.
I guess, the question I have is, how do you really practically balance the demands of the deadlines and needs of clients and pressure to move cases forward and pressure to bill a sufficient amount in an office setting with those self-care things and with your interests? And I think people probably find that hard to actually figure out in practice.
Well, we have target hours, but they're not unreasonable. And then we have, if people exceed those, then they get a bonus. But okay, let me back up for a minute. So the culture of the office is, and I went into each of the young lawyers. We don't call people associates here because I think it minimizes people. I went into one of the younger lawyers, colleagues in the office, and I said, okay, it's the beginning of the year. What's your career goal for the year? I said, and one of them said to me, you told me when you hired me, you were going to nudge me. I said, well, here I am. So, I want people to develop really good self-esteem, their professional presence, their careers. I am a pusher, of careers. Get yourself certified. Then when it's right, get yourself into the AML. Now I'm nudging somebody to get herself into the International Academy, because then there will be 3 of us there. So it is everybody knows what's expected of them. And sometimes we have to talk to people about their hours. But generally speaking, people are able to they manage to achieve a balance. I can't really explain how they do it exactly. I just hope that we're all fostering an environment where that's supported.
What do you do when you see somebody slipping, as both someone who cares and the ultimate presence in the practice? How do you deal with that? Both colleagues and clients, when you see the mental health, especially the mental health aspect that we've been talking about.
I go into the person's office and I close the door and I sit down and talk to them. A couple of weeks ago, I said to somebody, what's going on with you right now? I said, you seem very rattled. And I said, it's okay while you're talking to me, but it's not okay if you're talking to a client or if you're talking to another lawyer. So let's talk about what's going on, and talk about the concept of compartmentalizing, because, everybody has personal lives and we want people to be able to tend to their personal lives, but our clients shouldn't be tending to our personal lives. Right. So it is, and we don't want it interfering with somebody's judgment and their thoroughness. One of there's somebody in my office said we should have an office bingo of things that we all say and do. So there are 2 things that I always tell clients and lawyers and myself. So one is a mantra, which is, a reaction is not a strategy. And, clients lots of times want to resort to self-help. And usually it's going to bite them in the ass because it's a reactive choice that and the emotions that go with the reaction displace deliberation and reasoning and strategic thinking. So that's a mantra really for life. My son said, you should write a book about it. And I said, well, it'll just be one page. Reaction is not a strategy. I don't have much more than that to say about it.
Well, at least it's a title.
It's a title. I've got a title.
Yeah.
First page. The other is, and this is really for younger lawyers, the other is a fast answer or a fast solution is usually not the best one. And the reason that lawyers, especially younger lawyers, come up with that, so this is something we really work on here, is that it causes anxiety sometimes to not know an answer. And so rather than live with that anxiety in that space with that anxiety, people will come up with a quick answer so that their anxiety is allayed, but it's not the most creative answer. So being able to live with not knowing and being able to live with thinking about for a period of time usually generates a much more creative, much more interesting solution and answer than anything that's quick. So that's a learning curve for especially younger and intermediate lawyers, is to be able to live in that space where we don't know the answer yet. And now I'm in a place where I can say to a client, I want to think about that. But mostly it's invisible to the clients. It's a work process situation, what?
Yeah, I think that's really interesting. And I think what you said about, you have the experience and the patience now, and you're comfortable in that space, but that's of course earned. And I want to dig into that process a little bit and maybe roll back the clock and meet young Jill. Not associate Jill, because we're not going to use those words we learned already, but we're going to meet young Jill,
baby Jill,
baby lawyer Jill,
baby lawyer.
Yeah. And so let's start there. Let's start with, we can maybe go back a little bit more sometimes, but let's start with baby lawyer Jill, and really family law, right? Because I want to stay with family law for now. So what was your first family law case? Where were you at that point? And how did that first family law case find you?
Okay, so my very first family law case was in around 1978. I was a second chair, actually, in a trial in the middle of which was a huge earthquake. So it was very memorable. At that time, I was an associate in a general practice. The expert for the other side was being cross-examined. He was about to be impeached, and there was an earthquake. Okay, so
it's a good way to get off the hook.
Good way to get off the hook.
Yeah.
Right. And the thing that's most memorable is that the judge, who was in a robe, because this is the old courtrooms, was in a robe, ran off the bench and was clinging to the doorway to his chambers. Right. But
not exactly a distinguished look.
Not a distinguished look, but understandable.
Yeah.
So what I learned from that case, really what I learned from that case was a couple of things, but one of them, I think the most important one, was the personal relationship with the client. I can remember her. I remember what she looked like. I remember her name. Now, what I think you're referring to is that when I decided I wanted to do family law because I seemed to have a natural facility for that and interest in it, for whatever reasons. That's probably a whole 25 years of conversation. I put my name on the referral service for the San Francisco Bar Association. And so I came up on whatever their, cycle was. And I had a woman referred to me, and she called the office, and the receptionist yelled all the way down the hall, "Jill, there's a client on the phone and they're actually asking for you." And that was my first client. And she was a sort of working, if we still use those terms, working class pension, and a house down in I think South San Francisco or San Bruno, I can't remember which. And she was also the victim of domestic violence. It wasn't called that then. They were called battered women. We don't use that term really anymore. And the thing I reflect on with that, and I learned a lot from that case, because everything is a stepping stone and an education. But I think of her coming in to see me and putting her trust in me, and I must have looked like a baby to her. Just amazing to me. I'm grateful to young Jill that she did a good job for her, because I feel like, looking back from my perch now, her resources were very limited and she didn't have a lot of choice. And she had the benefit of the referral system, and I think I was $40 an hour. She had the benefit, $30 or $40 an hour. She had the benefit of the referral system, but she didn't have the benefit of unlimited resources. And so she ended up sitting across the table really from an inexperienced baby and baby lawyer. And so I'm grateful to young lawyer Jill. I did a good job for her. And I'm grateful to her for putting her trust in me, but I also realized she didn't have a lot of choice, which is an interesting angle on it I haven't really thought about before. But that sort of started me. That started me in my family, in my own family law practice. And then, a second referral came from the same source.
Now, oh, sorry, please go ahead. Tell us.
No, I was just going to say it's interesting because it's a foray into, I had been really being prepared to do personal injury work, and that is its own culture, very distinct culture of its own, plaintiff's personal injury work. And I started on my own making a foray into the family law culture, and it was unique and it was different and it was very interesting.
Well, that's what we want to hear about. We want to hear about what was the culture of family law like, especially during that time when there were a lot of transitions going on, like from fault to no fault.
Yeah, it's coming off of no fault. It's a few years post no fault. It's a few years post fault. The family law trials are still being sent out from the regular civil presiding judge's family law calendar. The family law court room was fortunately at that time run by Donald King, the appellate justice that just died, for whom the memorial is on Thursday. And he had an unlimited calendar. It was an old-fashioned courtroom. It was gigantic courtroom. The judge who preceded him was very old school, where if you came in with a domestic violence case, he would lecture the husband about laying his cape over the puddle like Sir Walter Raleigh and treating his wife with more courtesy. I mean, it was very stupid.
Yeah, archaic, really. I mean, that's
for
insane.
lack of a better word.
So backward.
It was just stupid, right?
Yeah.
Jerry Brown appointed Don King to be to the appellate court, and he had a vision, I think, of how to move into a no fault culture, and he was very sophisticated psychologically about what was going on in these cases. And so there started to be a shift where across the hall there were mediators who were social workers who would work with parents with kids, and but the lawyers who were now who I am, who were in their 50s, 60s, 70s, whatever, who had been practicing during fault. Some of them had a very difficult time extricating themselves from that state of mind. But also the women, the older women, some of them wore hats. So I'd go into court and I'd see these women with these hats on, and it was just so interesting to me. There was a very high percentage of lawyers who were Jewish in the family law bar in those days. And there was a pretty fair distribution between male and female. But some of the lawyers were really characters because they just come from a different culture. They'd been partners in firms that did personal injury work because the fault divorces were all trial work. If there were a paternity case, the baby was brought in and shown to a jury. I mean, it was just a different,
Wow.
yeah, it was just a different world, right? So I would say it's only in the last 10 or 15 years that the family law bar no longer has any of the lawyers who practice during fault. Maybe there's one or two, but very, very, very few. And the culture has just shifted tremendously. Now, in Los Angeles, according to the Northern California lawyers, okay, they're still a little bit more fault oriented in their culture, right? And Northern California, we're just more Northern California. What can I say?
Well, you do work in both. I mean,
I
you
do
have
work in
cases.
both.
Yeah.
Yeah.
So you get to see that.
Yeah. And that's not to say that there aren't problem solvers south and north, and there aren't problem creators south and north, and we know who they are.
Go ahead. Share.
Oh yeah, name
right.
names.
Yeah, name names, right?
Somebody will say to me, "What's my divorce going to cost?" And I say, "I can't tell you until I know who's representing your spouse, because the rhetoric of that is going to tell me a lot."
Yeah. And either way, it's probably not at the same $40 an hour rate that you were charging
it's not
in 1978.
It's not $40, even not taking into account inflation.
Sure, right. Yeah, and that's
right.
I think sticking with that idea, that beginning and that transition in the culture, making that decision to chart your own path through family law after you had maybe started by focusing on PI or feeling like you were going to be a PI lawyer, who did you rely on in support, right? That's a big move. You mentioned Justice King, but how did that impact you, and how did that evolve with your practice?
So, for a little while, I could ask lawyers around me, what's your opinion about this or that? But ultimately, also in the early days, we didn't use paralegals. And so every document was prepared by me. And there was nobody I could delegate to. So it doesn't mean that I didn't have a secretary. I did have a secretary. She used an IBM Selectric, with whiteout. But well, in the beginning, it was still carbon paper. But in terms of the sort of the infrastructure, the documentary infrastructure of a divorce, I did all of it. And I actually think that that's better training than what younger lawyers get now. But I did all of it, and I really had to fall back upon myself to think through what I was doing. And I also had to observe what was going on when I was in court or in a hearing. I was very observant of what was going on over the course of years. I started practicing with family law lawyers eventually in 1991. And then over the course of years, Justice King actually became both a judicial officer that I used, but also a mentor. And he would both, I think I used the language with you, Dan, he would both praise me and correct me. I'd get a phone call. So he created the idea of private judging and case management. And he did it from the chambers of the appellate court pro bono before he retired, while he was figuring it out. And so I had the privilege of working with him during that really embryonic period of that concept. And so a lot of it was also observing him, because he had a superb judicial temperament. And that is something that could be generalized to the practice of law. That sort of calming, one of his phrases, which somebody quoted back to me recently, because I quoted it to them, was, well, we are where we are. You know, you want to start complaining about something, he'd say, we are where we are. You know, so it was geared towards problem solving. I did try cases in front of him when he was on the Court of Appeals. And but it was over the course of years. When he retired from the appellate court, he became a private judge, and used him to the extent other lawyers would agree to. And occasionally I'd get a call from him, and I'd pick up the phone and he'd say, Jill, he said, stop interrupting so much. I said, okay, all right. I'd get another call from him, which would be, you know, Neil's a nice guy. He's a good guy. You got to give him a chance. And I'd say, okay, message, nicer, right? And sometimes, you know, I can remember an instance in which I had a case and the other lawyer was driving me nuts. And we were talking about a piece of jewelry. It was actually de Guigné. We were talking about a piece of jewelry, and she was calling it Schlumberger jewelry instead of Schlumberger. And it was driving me nuts. And so lunchtime came, and I said, I think I'm going to go have a hamburger for lunch. Nobody laughed. Justin did not laugh. Lesson. There's a lesson there. Right?
Well, and speaking of that case, can you tell us a little bit about the story? It's a very well-known published appellate opinion. We'd love to hear about that, as well as any other cases that stand out to you as real breakthroughs in your career.
That was a really interesting case because they lived in a 16,500 square foot Italianate villa on 29 acres, I think it was, in the middle of Hillsborough. Okay. And my client was the wife, and I'm not talking out of school because it's all published in public opinion. And the husband was, there are some things I wouldn't disclose, but the husband was there. And that I think was the first time that I thought, I bet it would be a really good idea to have the court come to the house and have one of our meetings at the house so that they can see how these people lived. Since one of the material factors was support, and because she and the children were entitled to be supported at a certain level, I thought, oh, and I probably have done this 6 or 7 times over the years. It's really interesting when it happens. So the judge, Justice King, came out to the house. We all met, the husband, his lawyer, my client. We had a tour of the place. The portrait, there was a major staircase, and the portrait of the husband's mother, huge, gigantic, was still there. Nothing was allowed to be moved or changed in the home during their marriage from the way it had been. But it was quite extraordinary. It had 2 kitchens, one for every day and one for entertaining. It had a vaulted room for silver. And up on the top floor, it had a room for wrapping presents. And it had a room for putting the presents before they're wrapped. But then it had a closet that had, like in the cleaners, one of those revolving, you push a button and the clothing thing would revolve. And I actually learned the correct way of hanging pants on hangers from this case. So you can always learn something, right? And
I didn't notice that. You didn't build that in your office for some reason.
Oh, right, I didn't.
I missed the gift wrapping room, the gift storing room, and the cleaner thing.
What can I say?
And the second kitchen.
And the second kitchen. And there were chickens, and the chickens were all named after society matrons. Okay. So they all have these names that in San Francisco were well known because that's how the chickens were named. Anyway, and orchids. Orchids were a big issue in the case. So we tried this case, and really we were trying a case about what should the support be, since there really was no community property. And the attorney on the other side suggested an amount that would have been psychologically and practically impossible for the client and her 2 children. And Justice King, as a result, and I made a different proposal, and Justice King, as a result, deviated from the California guidelines for support and utilized assets as opposed to income, because the husband had a practice of selling assets to generate resources, and ordered support that was actually an appropriate amount for the mother and the 2 children. But the shift in the law was the result of the fact that he deviated from support upwards because he said it would be unjust, and there is an allowance for that in the code, and utilized assets instead of income to make his order. It was a very interesting case. It was very contentious. That was where I made the joke that only I thought was funny.
Were there other cases like that one that stand out to you personally?
Well, probably the one that means the most to me is KM versus EG, which was to reunify a pair of twins with their mother, from whom they'd been taken because the mothers were the same sex, were both female, and the law did not recognize at that point her maternal rights in the same way that they recognized the other woman's. The other woman was what we call a gestational mother, which means that her uterus was used. And my client was the genetic mother because her ovum were used. And I just want to say, as I'm saying that, I'm remembering that I felt like the judge had googly eyes that were spinning around in his head because of the words he had to hear during the trial. But I am very eternally grateful to him because he let me make the record I felt I needed to make. It was a very challenging trial. It was 10 days. And it was a trial in which I prepared it for appeal. So I was anticipating where I thought the law should go and could go. And then I put on the evidence that would support the destination I was hoping to reach. And I expected to lose at the trial level, and I did lose at the trial level, but ultimately went up to the Supreme Court where we prevailed. And the twins were then, I used to get interviewed about this, and I used to say it would be really good news if this were a custody case. Because if it were a custody case, it means we had gotten past the parentage issue and my client had been recognized as a parent. So that's what it became. It became a custody case.
Can you tell us a little bit more about the appellate component to your practice and how it's different from your trial practice?
Well, I've always done my own appellate work. And the trial is creating the record that the appellate court reviews. And the standard of review on appeal depends upon what the issue is that's floating up to the appellate court. So everybody has a right to have the appellate court hear a review on request, but you don't have a right to have the Supreme Court review what the appellate court has done or what the trial court has done. So that's a very rarefied, those are usually issues of what we call first impression, where there's new law being made. Or the appellate court, the Supreme Court rejects review because they want to affirm what the appellate court did. They want to leave that as the standing law. But when you're trying a case, you're making a record. And when you're appealing a case, the clients don't even need to be in the courtroom when you're arguing the appeal. I mean, they are, but they don't need to be, because it's no longer about anything that they're going to say or anything witnesses are going to say. It's about the record and the testimony and the issues from the trial court. So when people think that a case might be appealed, it's very important for them to have an appellate lawyer involved from the very inception so that they understand what kind of record that they have to make at the appellate level if they're going to need to take an appeal. I think there's less activity in that area now than there was previous years because I think a lot of things have gotten settled in the law that weren't. But there are clearly still situations in which appeals are appropriate.
What hasn't been? I want to transition to the rest of your practice and kind of the current state of the law, but where would you like to see the law go now? What's missing? If you could design a case that you can argue up an appeal and win, what would that be?
Well, one thing I can tell you is I'm just waiting for the opportunity to try how equity compensation is divided between the community and the separate property. That may seem very dry and not interesting to you, but it is interesting to me. And one of the cases I tried in front of Justice King was to introduce a different theory on how those should be characterized as community or separate, even though he wrote the seminal case, one of the seminal cases, describing how equity compensation, but it was in 1985. Okay.
Mm.
So I think it's termed out. So I don't think there's a lot to complain about in terms of the status of California's family code. It's been made gender neutral. It's created equal rights for, there aren't the cracks that there used to be for families, modern, what I call modern families. It's really a European term, modern families, where like with the twins, there's an opportunity for them to fall between the cracks and not be protected. That really has been pretty much tended to. I think that there has been an effort to create an integrated system that recognizes both law and equity. I think we have a pretty good system here. And I'd have to spend some time thinking about what would I like to see that would be different. I think with the development of private judging, there's opportunity inequality. There's recourse inequality. Our courts are underfunded. I'd like to see the courts. I'd like to see the court system enriched. Really, I think if we want to look at where's the weak link is access to representation and courts being underfunded and not having enough, the judges not having enough help.
So I think let's put a pin in the private judging thing because I think I want to come back to that. But sticking with the law part of it and the practice, if California is in a much healthier place now than when it started, in your practice now, if we kind of get out of California, you're doing a lot of international work now.
Yeah.
So what have you learned from that work, and what's really most striking and interesting about some of the international systems that you've come in contact with?
Well, for one thing, most of the systems outside of the United States have a unified system of family law. So people from outside the United States look at us and they think, oh my God, you've got 50 or 52 different family law systems because each state has its own. And then we have territories, right? But if you go to the Scandinavian countries or you go to France, they have a unified system. Now they may have districts, districts with their own district courts and things like that, but they don't have what we have, like California's a community property state, but New York's an equitable division state. They're really different. They don't have those differences. There are differences in the United Kingdom, somewhat. England and Wales, that's a single bar association, England and Wales. But things can be a little bit different in Scotland. And so for when you get to prenuptial agreements, that's really a different, that's really different. Now, I've been looking more at Africa lately, and in the African systems, they're very rarely have, at least in the African systems that I've become more familiar with, those countries rarely have dedicated family law firms. There might be one or two, but mostly they don't have the resources. There's not enough to support economically, support a firm that does only family law. So you tend to have more general practices still in those countries. And the problems that they're concerned with are different than the problems that the Western family law courts are concerned with. And so I've learned a lot about protocols and the culture and the priorities in these different parts of the world. Actually, there's a lot of cross-border work with Hong Kong. There's a lot of cross-border work with Europe, and there's a lot of cross-border work with the United Kingdom. There is not an equal amount of cross-border work yet with the African countries. And I have a couple of young women who are mentees in Kenya. And, the things, and I spent a day with law students in Nairobi, and they were presenting papers of things of their concern. And they're worrying about things like climate change resulting in forced child marriage, and what to do about that, and how to reconcile what they call the customary practices, which are the tribal practices. There are, I think, 40 or 41 tribes in Kenya, for example, and the 42nd are the Southeast Asians that live there. How to reconcile the tribal customs with their constitution, which really came from a European colonial power. And how do you reconcile these? And so when I look at those, when I listen to these kinds of problems that they're talking about, they're very far away from a place in which they're going to be worrying about whether two women, one gestational and one genetic,
Right.
can both be mothers legally, right? Which probably is non-existent in most of these countries or any of those countries right now. Or people can be same-sex parents or same-sex married. That is really not right. What's in front yet? What's in front of these young lawyers who are starting out and trying to figure out how to make their way through these systems that are so different than ours. The closest analogy we have is conflict resolution, differences between conflict resolution in our Western system here versus in our indigenous tribal systems. It's really interesting. And we do have some barriers in our legal systems between tribal customs of the Native Americans and ourselves. But generally speaking, everybody's subject to the jurisdiction of our courts. And over there, it's just, they still have multiple wives. And then how do you figure out who gets the property if there's a divorce? So it's it's just a completely different thought environment, really. Really interesting.
So what I'm curious about is from your exposure to all these different systems that you were just talking about, and different countries and their family law structures. Is there anything in particular that jumps out to you that you would like to see integrated in our system that's absent from our system? Or not?
No, well, our system, there are 52 our systems,
Right.
right? And so I think California's, my opinion, what's the California normative? I'm speaking from a California normative point of view. I think our system is pretty good, okay? But for access inequality that I was referring to earlier, And so I don't know. I don't know that there's anything from those systems that I think would be better here. I mean, you know, France and Portugal, for example, have a civil law system, so their idea around premarital agreements is very different than ours. England has a common law system like we do, you know, where a lot of law is made through decisions of courts, reviewing courts, and evolves. And so that's what I have to do when I'm doing cross-border work is we have to integrate. We have to figure out, is it possible to integrate the two systems in some way? And it's not that I think one is necessarily better than the other, they just are. And so how do you integrate them to enable the people to get the best help that they can get? And sometimes it's really, in which country are you better off getting a divorce? Right? In which country is child support going to be less than California? Or will spousal maintenance be more than California? Or, you know, how do you get jurisdiction and how do you decide where you want to be? And so there are nuances embedded in just the general legal system that they have. Ultimately, a lot of it's not. Ultimately, the idea of marital property does exist in these places, but not necessarily with all the nuances that we have here in California.
So let's bring it back hyper local. We went overseas. Let's bring it all the way back. You talked about Silicon Valley. I want to go there, especially because that is one of the things that you're most well known for, is working on some of these big tech entrepreneur cases. That's been a big change since you started, right? It really has been an industrial revolution.
Yeah, right. I call it the industrial.
Right, that's what you call it.
Right. So, you know, the aspirational cases when I was a young lawyer was a partner in a law firm, you know, and a house and whatever else that they had accumulated. Those were the aspirational cases. And first of all, the practice of law has changed and remuneration in the practice of law has changed. So that's one thing. But yeah, there's been an industrial revolution, and it's not only about tech and equity compensation. There's fintech in the financial sector. There are not so much hedge funds so much as VC. A lot of venture entities, and it's sort of an amalgam of, you know, which is it going to be that somebody's bringing in? Is it something from the tech world with their equity compensation and all of those things? Is there going to be intellectual property? Is there going to be, or is it going to be a really complicated infrastructure to a venture capital firm?
So that's the subject matter, but that's also kind of this new money psychology, right? That somebody who is in that one of those worlds, whichever one you want to pick, is creating extraordinary amounts of, some might argue, disproportionate wealth, right? So how has that changed litigating a new money case versus, because there's still a lot of, I mean, San Francisco, you still got a lot of old money up there too. Is there a difference? I mean, we can kind of start to wrap up by going back to the psychological piece of it that we talked about at the top. Let's go back to that. How's the psychological aspects of those different?
The reason I'm sort of laughing is because some of the tech people, they have their own sort of universes in which they live. The old money families obviously live at a level of affluence that is not average, but they are plugged in. They're still plugged into the world that we're all living in to a much greater extent. And what's really interesting to me is are the families where the children of the older wealth are themselves very productive and entrepreneurial, and are going not only to rely upon that wealth, but increase that wealth and utilize that wealth in creative and interesting ways. And the families where the offspring instead choose sort of projects that are never going to make money, that they can only do because they have trust funds. Okay, those are really different. Those are really different environments within which to work. The old money with the really productive next generation, those are they tend to be very interesting. I think I told you the story many years ago, actually maybe 20 years ago. One of my clients said to me, Jill, I'm going to the Grove for the weekend. And I said, why would you be going to the Grove for the weekend? He says, what do you mean? I'm going to the Grove for the weekend. All right. For me, the Grove was Sigmundstern Grove, which is a dog park near my house. For him, the Grove was the Bohemian Grove, which is this enclave by Russian River for all of this old money, affluent men, right? And I said so we were laughing. I said, that's what you get for hiring a Jewish woman lawyer. But it's but so you learn, you become, you learn by immersion. You learn about it, and they're just different cultures. The tech, new money, venture capital, these are first generation. This is money generated by this is G1, as they call it in dynastic talk, right? This is G1. They're G1s, and they're interesting people, and they're smart, and I like to work with them. Okay. But then we have the G3s, the G2s, the G3s, the G4s, right? And they're also very interesting when they're on the move, and they're entrepreneurial, and they're really smart, and they're thoughtful, and they're generous. They tend to be generous. And they also tend to be a little bit more integrated into the popular culture we all know,
Did it change the psychology of the case though? Like that G1 versus G5, probably into G4s and fives now. You're talking about that's our language too.
Mostly threes and fours.
Yeah.
Prenuptial agreements are different for each of them, because when you're doing prenuptial agreements for G1, their interests are different than the prenuptial agreements for G3, where the worries and concerns are really in G2 and G1. Okay.
Right.
So we're not really talking about prenups, but that's a whole, I do a lot of those. That's a whole nother, and that's always dynastic. It's almost always for dynastic reasons. And, but psychologically, the new money people are just involved in themselves in a different way than the old money people. Maybe that's
a diplomatic way of putting it.
Maybe that's the way to put it. Yeah. Yeah.
Well, Jill, we only have a few minutes left. So for those last few minutes, we want to shift even, closer and turn back to your practice.
Sure.
What keeps you motivated on challenging days, in your everyday practice?
Well, I just love what I'm doing.
That helps.
What can I say?
The kind of, if you love what you do, you're not working it, you don't work a day in your life.
Yeah,
sort of thing.
I mean, I love what I'm doing. I think my life is balanced. I love what I'm doing, and I love the opportunities that it has presented me with in terms of teaching and mentoring. I do a lot of mentoring, and I'm working with people, And I've had the experience of people coming up to me and they'll say, you did my son's divorce 10 years ago. Oh my God, was fantastic. Or, sometimes it's thankless. It is, but sometimes it's unbelievably gratifying. And to watch somebody move through the process and come out in a different, more consolidated way than they went in is really a pretty moving experience. And I don't, people say to me, you see people at their worst, and I don't think that's true. I see people in the middle of tremendous transition, trauma, distress, all of the responses that, there are margins, but generally speaking, all of the responses you would expect to somebody going through something that's really terrible, which I am watching and seeing as really, really a traumatic and difficult transition for people. So I think we're taking people through those transitions, and I hope you're not always, relationships aren't always sustainable, but I hope for the most part that we're giving them the attention and the support that they need and the advice and also we are not yes people. So there has to be a healthy alliance, and they have to be able to understand that the advice we're giving them is to take care of them, even though it might not be the best answer or the most emotionally gratifying answer for them. But I don't see any one day being particularly more challenging than the other. It's just, I like what I do, and I really love my clients.
That's great. I can't think of a better place to end it. And Jill, thank you so much.
Well, thank you
for spending so much time with us. It's really been great.
Yeah. Thanks, Dan. Thank you. Both of you.
Thank you, Jill. And just for our listeners, we have an exciting slate of new episodes coming up, both individual interviews and more roundtables. Remember, you can find BHBA's Direct Examination presented by UBS on all podcast sites and, of course, on our own website. We will see you all next time.